Should be all set, Your Honor. Just waiting for them to unmute. Should be all set.
Good morning. This is case number 19-20569 NI, Schwaller versus Lane. The court recognizes Attorney Coop and Attorney Zaid, and this is the defendant's motion for summary disposition. You can go ahead, Ms. Coop.
Morning, Your Honor. Andrea Coop on behalf of Harry Lane. I'll be brief. I just want to respond to some of the points brought up in plaintiff's response brief, as I know that you've read the briefs and the motions and you're well caught up. This is a third-party tort claim brought by Ms. Schwaller against Harry Lane. Liability is not an issue. As you know, she suffered a skin shear on her leg that caused scarring. The basis of the motion is that the skin shear, although it meets the threshold for the permanent disfigurement part of the no-fault statute, it does not meet the injuries resulting from the skin shear do not meet the affecting the daily life. They were not serious impairment of bodily functions that affected her ability to lead her normal life. At her deposition, Ms. Schwaller explained that she still drives 30,000 miles a year for work. She still works. She walked out of the hospital on the day of. She went on a lavish vacation that required her to fly to Maine and then drive 4 hours each way with her sister about a month after the accident. The No Fault Act and the McCormick test, they have to mean something. It has a serious impairment of bodily function that affects your ability to lead your normal life, has to mean something. It's not, I play golf, but it bothers me to play golf. No, you're still playing golf. In this regard, she's still driving. She's still going to the grocery store. It's not, I'm no longer driving my small car. I have to drive the big car. She's still driving. She's driving a car. And I did want to touch on where Mr. Zaid brings up that if you pierce one part of the veil, you pierce it all. MCL 500-3135-1 discusses the three things that you can be compensated for under the No Fault Act: death, serious impairment of bodily function that affects your ability to lead your normal life, and serious disfigurement. And then if you move down into 500-3135-5, you see where serious impairment of bodily function is defined. You can't get one without the other. The list is not, it's not all inclusive. It's not just because I hit serious disfigurement, I then get everything. You have to look to a different part of the statute. And McCormick is clear on that as well. McCormick came out in 2013. It supersedes any case law from 1982, which is cited by the plaintiff in this regard. And then lastly, Mr. Zaid or his co-counsel who was there for Ms. Schwaller's deposition had just as much opportunity to expand on his client's testimony as I would have. And the affidavit does not contradict anything in her testimony. She's still able to drive 30,000 miles a year. She's still able to go on vacation. And she doesn't say that she's not, even in her affidavit. The last sentence, it looks like paragraph 9 of her affidavit, where I was never asked about how the scar affects me emotionally. We've never said that she's not entitled to compensation for the scar. The scar is there. It's a serious disfigurement, and we acknowledge that. And any damages that come out of the scar, they are already compensable under that part of the statute, the serious disfigurement area. So unless you have any questions, I'll pass the torch.
Thank you, Andrea. Judd, may I begin, or do you have questions for Ms. Coop?
I did have just a question for Ms. Coop, so I guess I'm just a little bit confused. Are you taking the position that with a permanent serious disfigurement, that still has to affect a person's ability to live their normal life?
No, Your Honor. indicating that she would be entitled to compensation, whatever a jury determines, because of the scarring. There's no additional testing beyond that. We're arguing that her emotional issues of PTSD and anxiety and the like do not meet the third prong, the objective serious impairment of bodily function that affects her ability to lead her life. That's what this motion is about.
Oh, okay, all right. You can go ahead, Mr. Zaid.
Thanks, Your Honor. And this is Brian Zaid on behalf of the plaintiff Pamela Schwalier. I'll be brief as well, Your Honor, because I think it's pretty straightforward and well written in both briefs by Ms. Coop and myself. What I'd like to address is basically to point out that in the case that I cited, Incarnati versus Savage, as well as the others that have been ruled upon subsequently and previously, I think this issue has been addressed, that when you do pierce one prong of the threshold, you're entitled to explain to the jury all of your issues, because in fact, those are all of the damages that are compensable. Pretty straightforward. However, if the court is inclined to actually determine upon a serious impairment, I also further believe that my client has suffered a serious impairment, because although her statements are that her scar affects her emotionally, I think emotional effect is also something that should be taken into consideration as to how it affected her ability to lead her normal life. When you go through the procedures that my client went through, 5 grafting procedures, 7 different times that her scar was scooped, over 3 months of treatment for the physical nature of the scar, there's certainly an impairment on her life in that regard. And then when you have to couple that with the fact that she has emotional issues of anxiety and also a more physical manifestation of an emotional issue like PTSD, where she wakes up with night terrors, when she wakes up with nightmares, when she has recurrences watching movies, those things, although they were addressed in the deposition, the affidavit gives further support and specific examples of which for the purposes of the motion, which we're entitled to do. So just because she's able to travel and just because she's able to golf doesn't mean her life isn't affected. And I use the word golf because I think that was an example. And I think what was more important to my client was the fact that because she travels a lot and because of her work, she's forced to travel a lot. It shouldn't just be, oh, well, you're good to go. You just have to deal with the emotional aspects. That's not the way it works. And I get that the motion is brought based on the law that's been established under McCormick, and that we need to have a threshold pierced. I think this case meets that, not just with the scarring, which pierces all, but also because of the effect it's had on her emotional stability. And I think that came across well during her dep, based on my co-counsel, Mr. Boringer, who took the deposition. So for that purpose, Your Honor, I would ask that the motion get denied. But the one last thing I want to point out is it was stated that my client walked out of the hospital. I'm thankful that my client could walk out of the hospital. Although our firm, in my cases specifically, are of the significant variety, I don't think judging it or the ability of a patient to walk out of the hospital should be a basis for saying, okay, well, someone was at fault, they admitted it. Someone caused a permanent scar, they admitted it. Someone suffered PTSD, they admitted it. However, because she walked out of the hospital, she might not meet the threshold. I'd have a lot of cases dismissed, and I don't think that was the intent of the statute, McCormick, which is now codified. Thank you, Your Honor. For that, again, I ask that the motion get dismissed or denied.
All right, any rebuttal, Ms. Coop?
Briefly, I'm obviously not saying because she walked out of the hospital that she wasn't injured. We're saying because of her own testimony, the motion is based on her testimony that she continued to drive in excess of 30,000 miles a year. And she's saying that the PTSD affects my ability to drive. It's not, if she would have said I only drive 10,000 miles a year because of the pain and because of the emotional issues I have with driving, but that's not what she said. She says, I still drive 30,000 miles a year. I still do it. I still go on vacation with my sister a month later and drive 4 hours from Maine to Canada. I still do it. It just, maybe it's uncomfortable or annoying now. And that's not the standard under McCormick or the No Fault Act. That's why we have the standard of serious impairment of bodily function that affects your ability. That's why there has to be a meaning for the test.
Your Honor, if I could just reply to that for 1 second.
Okay.
I'll leave you with this. I think the paramount case under the circumstances in Incarnati versus Savage is, and I quote, once this threshold has been crossed by a particular plaintiff, the defendant remains liable for all non-economic loss suffered by the plaintiff. So regardless of, I think it's irrelevant as to whether or not she is able to drive for work with or without the anxiety issues. I think because of the permanent serious disfigurement that she sustained and the treatment therewith, it's pierced and she's entitled to damages for all non-economic loss.
All right, thank you. You'll get an opinion shortly.
Thank you.
Thank you.